All right, hello and welcome to this criminal law capsule. I am going to talk to you about the doctrine of transferred intent in the criminal law. It is an area that has a few complications that need to be understood if you're going to really understand the way in which mens rea works in Canadian law. So let's get right to it. Let me just say that as I'm doing this capsule, I am going to start off the long majority of this capsule will be essentially setting out the way in which the law works today. So I'll give you a full and detailed description of what the law is. And at the end of the capsule, I will express a few concerns and suggest alternatives to the way in which the law of transferred intent actually works. Now, the doctrine of transferred intent is an interesting one, and you can actually draw a parallel or a connector between the situations in which transferred intent arises. And what this doctrine really has to do with is where there is some sort of mistake on the part of the accused. In other words, the accused, I don't want to say lacks the mens rea, because as you'll see, it's not always that simple, but the situation in which there is some sort of mistake that the accused makes. And the idea is that you can transfer his or her wrongful intent, notwithstanding the mistake, to find him or her culpable. And I'm going to try and simplify the idea of the doctrine of criminal mistake. I mean, first, as I said, you have to understand there is a mistake. So let's assume from the outset in every situation that I'm about to give you that there is an honest mistake. The accused, something happens that is different from what the accused wants. Keep in mind, if there is no honest mistake, we don't need to talk about transfer. If the accused is just lying and didn't make a mistake, there's no point in talking about the transferred intent doctrine. Similarly, if the accused is reckless and a result occurs that is slightly unanticipated but that the accused is aware of, we don't need to talk about transferred intent. Transferred intent only arises where there is a legitimate mistake on the part of the accused. And I'm going to categorize the doctrines in which transferred intent could potentially arise into three situations. Okay, and this is a way that I think is helpful for you to think about it. So number one is the situation where you don't need transferred intent. In other words, there's a mistake of some kind, but you don't even need to think about the doctrine at all, even though it looks like you might. So don't worry if you don't understand that now. It will make sense as I go forward. The second situation is where you shouldn't use it because it's inapplicable for some reason. And there are two discrete situations in which that can arise. So these are the ones you have to be very aware of, number two, because if you do use the doctrine of transferred intent in these situations, you come to the incorrect result. And I'll detail these. And then is the third one, of course, where you can use it, where it's well accepted as a doctrine in Canadian law, and I will go through those. And then at the end of this, as I suggested, I'm gonna come to the conclusion that you never should use it, because I don't agree with situation 3, and I will go on to tell you why I don't think you should ever use the doctrine of transferred intent, but I stress that is simply my opinion as a law professor. I am going to tell you that the law does allow you to use the doctrine of transferred intent in certain situations. So let's start with the first situation. Situations of mistake in which you do not even need to refer to the doctrine of transferred intent. And the reason for that is because I will argue that these sorts of mistakes have nothing to do with the actus reus of the particular offense. So the accused does make some sort of mistake, but that mistake doesn't actually matter. And the reason is because the accused has the full mens rea that's required for the particular crime. So let me give you an example of that, because I think this becomes a little bit more concrete when we're dealing with examples. And as I go forward, try to think of the differences between the examples that I give you, because that will really help to understand when transferred intent can be used and when it's completely unnecessary. So let's say we have our offender A, and A wants to go and attack B. So A goes forward, and A decides to assault B. So the crime here is assault, which means intentionally apply force. Okay? And A goes and decides, I'm going to assault B. But the only problem is, unbeknownst to A, it's not B, it's C. So A ends up punching C in the head. Now, is there a mistake? Yes. Do you need the doctrine of transferred intent? Absolutely not. And the reason is because in these circumstances, the identity of the victim is irrelevant. As long as you intended to apply force to a person, A had no right to apply force to B or C. So the actual crime is completed. There's no need to talk about transferred intent. The error is immaterial. I'll give you another example. Let's assume that A wants to go and take a car. So A is going to go and take this car, okay? And A, wants to steal this car and believes that it's B's car. I want to steal B's car because I don't like that guy. If it ends up being C's car, again, it's immaterial to the offense. The offense is, did you deprive someone of their property? The identity of the victim is completely irrelevant to offending, so therefore there's no need to transfer intent. What you're really saying in these circumstances is that mistake is irrelevant. All right, let's go to situation number 2, where you can't use it. And there are 2 situations in which you can't use it, and I will explain to you. One of them looks a little bit like this situation, and one of them is quite different. All right, what are situations in which you cannot use the doctrine of transferred intent? Very simple. These situations arise in two different categories. The first, you cannot use the doctrine of criminal transferred intent in situations where, first of all, there is no illegal intent. And I'll show you what I mean by that. It looks a little bit like the other scenario, but the difference between this scenario and the first one I drew for you is that A intended to assault somebody and assaulted the wrong person. In situation 1 that I'm going to describe to you, the resulting act has the actus reus of a criminal assault or a criminal charge, but there is no illegal intent because the person did not have the mens rea required to commit the crime. The second situation is where there is an illegal intent, but the illegal intent does not match the crime for which the person is charged. And it's very clear under Canadian law that you cannot transfer intent in this situation. Let me go through both. The situation of no illegal intent is an important one to keep in mind. You can never transfer intent when the person does not have the intent required to commit the crime, and that is the hallmark of the 2 situations I'm about to describe. Let us say, for example, that A and his girlfriend B decide they want to have a sort of a different kind of sexual encounter. So A agrees that he's going to find B. Okay, B's going to, let's say, rent a hotel room and give A the number of that hotel room, room 706, okay? And A is going to come in and they're going to have some, fun encounter because it's all very secretive and whatever. A gets the message, but for whatever reason, okay, and I realize the example's far-fetched, but I want you to get the idea. The number on that he gets is room 906, okay? So A goes to room 906, and by happenstance, the room is open, climbs into bed with C, and begins to, fondle C. C screams, and A runs out of the room. There's actually a case that's not far off this particular description. Do we have a sexual assault in this scenario? Well, A touched C without C's consent, so we have the intentional application of force, right? The intentional application of force without consent. And if you go through, there are arguments to be made that, there was no honest mistaken belief in consent because A did not have reasonable belief or take reasonable steps to ascertain that it was C. But forget about all that, because the problem is, what you are doing is, in this case, you are transferring intent. You don't even realize you're doing it. A intended to apply force to B, and in this case, the actual person matters because that's what A is trying to do. A is trying to apply force to B with consent, and he knows he has that consent. But A makes a mistake about his location and ends up touching C. The problem is that A never intended to touch C at all. A doesn't know C, he had no desire to touch C, and he had no knowledge that he was touching C. So there is no intent, and you simply cannot transfer his intention to apply force, which is his mens rea here, over here, and suddenly make it criminal. And the reason for that is because A had no belief that he was doing anything criminal, and no criminal intent. The basic bottom line rule is, where A is participating in an act that A believes is legal, for all reasons, the mistake cannot be transferred. And that is an important part of the doctrine of transferred intent. So therefore, situation number 1 sets up a rule. If the intention or knowledge went to a legal act, you can't transfer that intention to ground an illegal act. You just can't do it. It's not a proper use of the transfer intent doctrine. If you think about it, it makes perfect sense. The problem is that A had no mens rea to commit any crime. A made a mistake. It's an honest mistake, and it's not about consent. The mistake was who he was touching. So he never had the intention to apply force. You cannot transfer it to his victim. Now, the second situation is a little bit different, because in the second situation, we have illegal intent. So here's the quintessential example, okay? Let's say A is upset. So A decides, I'm going to cause mischief. And A picks up a rock. And remember, there's no recklessness here. Don't create a situation where A was aware of risk and whatever. No, A has no awareness of risk. A decides, I am going to throw this rock at a window and break it. There we go. So now it's different from the last example because we have illegal intent. A wants to break a window, which is damaged property, which constitutes mischief. But A throws the rock, the window opens, and hits B in the head, causing damage. Great. Now, forget about the mischief. Can we charge A with assault? Or, if it's real damage, aggravated assault? And the answer should be apparent. The answer is no, although some courts have tried to do it. Can you charge A with assault? No. You can't charge them with assault because they had no intention to apply force to B. It's very, very simple. The intention that they had was to break a window. So they had an intention to apply force to property, but you cannot transfer one intent to another. Because if you just think about basic principles of mens rea, A never intended to assault B. And therefore, it is improper to transfer intent in this way because you were essentially finding A culpable for anything that results. And that goes against the basic principle of subjective mens rea. Now, in this scenario, A does not get off the hook. You want to know what A gets charged with? The proper charge for A is attempted mischief. Now, keep in mind, the window didn't break. So A did not commit the crime of mischief, but they attempted to commit mischief. You can also argue, and this is, more controversial, but you can argue that A is actually guilty of other crimes as well. By hitting B with the rock, you can try, if you like, and, I could imagine a Crown would, to prosecute A for a variety of other charges, like, criminal negligence, if there was a worry that there was a reason to believe that throwing the rock at the window would cause harm, or a reasonable person, it was a marked departure, whatever. I don't want to go through the criminal negligence test. You could even try, there is a crime called unlawful act, cause harm. And that would be the appropriate crime. You could say, well, the attempted mischief was the unlawful act, and it caused bodily harm in the circumstances. Now, I'm not going to go through every one of these crimes. I'm not sure that A can be prosecuted of either criminal negligence or unlawful act bodily harm, because that will require consideration of those crimes. The bottom line is you cannot transfer the intent from one crime, mischief, to another crime because it would essentially be giving A mens rea that he did not have. He never tried to apply force. Very important rule, well established in Canadian law. Okay, so where can you actually use the doctrine of transferred intent? Well, there are two places in which you can use the doctrine of transferred intent in Canadian law. The first is where the statute says that you can. So take a look at this provision, Section 229B of the Criminal Code. Culpable homicide is murder where a person means to cause death to a human being, right, that he knows is likely to cause his death, and being reckless whether death ensues or not, by accident or mistake causes death to another human being, notwithstanding that he did not mean to cause death or bodily harm to that human being. Well, there's transferred intent. And that's really important. So I'll show you what that means. That is called transferring intent within an offense. And as I'm going to show you, I would argue that this essentially codifies the common law. But it's because I don't think the common law is very good and should evolve. The statutory provision could be important in years to come. But I mean, that's if they ever adopt what a law professor thinks. But in any event, within an offense. So what happens here? A wants to kill B. And this is different. Keep in mind, look at how this is different from my first example. A is trying to kill B. He's running after B, he's got his gun out, he's going to shoot. I want to kill B, I want to kill B, I want to kill B, but B ducks behind C at the moment A shoots. Boom. Now, this is different from my first example. If you think about my first example, I said you don't need the doctrine of transferred intent, because if A tries to shoot B and it's actually C, A did exactly what he intended to do. He shot this person. But in the scenario I've just given you, let's assume for the moment that A has no interest whatsoever in shooting C and isn't reckless either shooting C. It's really unanticipated. C jumps out of a doorway, boom, gets hit. Totally unanticipated. A has no interest whatsoever in killing C. Just wants to kill B. Well, in this case, you're transferring intent. And how are you transferring intent? A fully intends to kill B. Intends. You don't even need recklessness. And therefore, that intent is then transferred to C by the statutory provision. By accident or mistake, causes death to another human being. And this provision can be used in a variety of ways. You don't even need my C example. Anytime you have trying to kill somebody in any crazy way and something happens, you are guilty. That is transferred intent. This is different from the other examples I've given you for two reasons. It's different from the first example, as I showed you, because there's no mistake of identity. There's a mistake of circumstance. C has, by unfortunate circumstance, become a different victim from who A intended. Okay? It's also different from the other example because it's within the same offense. You can't argue, unlike my mischief example, that A doesn't have the intent to kill. He does. He just ends up killing somebody different than what he has. So A satisfies all the mens rea requirements for murder. You don't need the statutory provision to do this. This is a well-accepted case called Deacon that's been pretty much adopted everywhere. What happened in Deacon is very simple or very complicated, depending on your view of transferred intent. A wants to hit B, okay? And A clearly wants to hit B. Assault is fine. But A swings his hand, hits some glass fragments, some glass ornaments or something, misses B, but sends these glass ornaments flying against the wall, where, I'm not kidding, the glass ornaments crack and one lodges in C's eye. So, for all those cases, all those times your mom worried you not to throw things because you strike somebody in the eye, that's what happened in Deacon. Now, so what did the court find in this case? Well, A never intended to hit the glass ornaments, or C. So A doesn't have the intention to commit what amounted to an aggravated assault because of the nature of the injury upon C. But A did have the intention to apply force to B. So they transferred the intent from A to C. And there you go. And they say, well, you had all the intentional elements of the offense. You intended to apply force without consent against B. And what happened is you ended up applying force against C. Therefore, under the doctrine of transferred intent, even though you never intended to apply force to C, you are guilty of aggravated assault. And in a nutshell, that is the doctrine of transferred intent. Anytime you have the wrongful intent for a crime, you can be punished for that crime if you end up, by any circumstance really, causing the harm required to another person. That is the doctrine of transferred intent. Now, as I promised, I'm going to tell you what I think is wrong with the doctrine of transferred intent. I'm going to suggest to you that it doesn't make any sense. And frankly, I'm also going to suggest to you that I don't think it's necessary, and I'll tell you why. I believe that you should be punished for what you actually do. And, you know, I'm not going to hang the rest of my career on this, but I do believe that where A tries to assault B and accidentally causes harm to C, well, A has not intended to cause any harm to C. They just didn't. They haven't satisfied the mens rea of that offense. So when you charge them with A, assaults bodily harm against C, you're actually charging them for something they didn't do. And I think there's two problems with that. One, it misstates their liability. I mean, look at Deacon. We don't know what Deacon intended, but at best, he assaulted some property that had an unfortunate effect of slapping someone, hitting someone in the eye. And by all means, I'm not suggesting that A should be acquitted. A should not be acquitted, but A should be charged and convicted and sentenced properly. Because essentially, again, you're creating a legal fiction to say that A actually assaulted, causes bodily harm to C, when all A really did was attempt to assault B. And I would argue that that is the correct charge. So A attempted to assault B. So if A attempts to assault B and causes harm to C, the proper charge is attempt, assault, whatever it is, aggravated assault or attempt bodily harm. That's number one. But I would also argue that the problem with transferred intent is that you arguably underrepresent A's liability, because the real thing that should be happening is that A should be liable not of one thing, but of two things, and whatever that second thing is. And that's not going to be possible in every case, but it'll be possible in a lot of cases. You know, criminal negligence caused bodily harm to C for their crazy actions, depending how crazy they were. Or as I suggested earlier, unlawful act caused harm to C. And I don't have a problem with that because I think it accurately reflects what A is doing. So A actually has attempted to cause B, but in the process has caused harm to a third party, and they should be recognized for that particular harm. The idea of simply transferring their intent, I think, misrepresents their liability. At the end of the day, I'm just telling you that conceptually, I don't think the doctrine makes any sense. At the end of the day, I don't really think there's a lot of difference between the two. The reason is, 99 times out of 100, you'll be able to convict A of either the attempt and or the secondary offense. And realistically, in sentencing, a judge would really consider the harm that was done to C as the main part of the package, although I'd suggest where you have two charges, they would more accurately look at what was really going on, both the attempt and the actual causing of harm, instead of just the transferred harm. But honestly, I don't think there's a big real difference, and that's why I think the doctrine has been allowed to survive, because it really doesn't matter that much. But let me show you a situation in which it does. It's a really interesting Ontario Court of Appeal case called Gordon, and they said in Gordon that you cannot transfer intent where you're dealing with attempt charges. And this is really interesting, and I'll show you why in this case. So here's what happened in Gordon. In Gordon, you have this guy, A, who's trying to kill B. And he's running around with a shotgun, you know, kind of crazily. Running around with a shotgun and attempting to murder B. But B gets away. But in the process, A injures C, D, and E. Okay? So what the court tries to do, and the court did this at the trial level, was say, well, A did not attempt to murder C, D, and E, but A attempted to murder B. So therefore, we'll just transfer the intent from that to C, D, and E. Well, that's just crazy, as the Court of Appeal recognized. And let me be clear. When A ultimately gets convicted, he gets convicted of the attempt murder for B. There's no problem there. He was trying to murder B, and he accepts that he was guilty of that attempted murder. The problem with punishing him with 4 counts of attempted murder, just because these guys were hit, is the problems, first of all, it doesn't make sense. Again, as I said, he never attempted to murder C, D, and E. But if you even use the transfer doctrine, there's a problem, because essentially, like, you could transfer that attempt to anyone. Like, the number of charges he could face would be infinite, because ultimately the fact that C, D, and E were injured is immaterial. The attempt is not premised on their injury. The attempt is premised on how many people he was trying to kill. Why stop at C, D, and E? He was shooting in a crowded location. He could have 50 counts of attempted murder. And what you would do is you'd say, well, he attempted to murder everybody there. He just didn't get them. And therefore, you've attempted to murder every individual who was in the way. It just doesn't make any sense. The better way to do it, as the court recognized, is once again, do what I said earlier. Charge him with the attempted murder, which he was clearly trying to murder B, no problem there, and then charge him with whatever other crime you want, reckless discharge of a firearm, who cares, criminal negligence, with respect to the people who were actually injured. And that, again, is a better, more consistent view of liability than saying he attempted to murder 4 people. He clearly didn't attempt to murder 4 people. He attempted to murder 1 and injured 3 in the process. So again, the court in Gordon said with attempts especially, the doctrine of transferred intent simply makes no sense. I realize that for some of you, some of this might have been a little confusing because we haven't dealt with the law of attempts, or you may not have if you're watching this capsule from somewhere else, but it will make sense as we go forward, and it's important to keep in mind the way in which the transferred intent doctrine works, simply because I think it'll give you a much richer understanding of the law of mens rea. In any event, that's more than enough for this particular capsule. If you have any questions, let me know, but for now, have a great day.